Very good. Good morning, Council. My name is Steve Hill, and I have been designated as the presiding judge of this panel of the Court of Appeals. It's my honor and great pleasure to be serving on this panel with two distinguished judges, Judge Tom Malone, who is one of our more senior judges on our court, and Judge Richard Walker, who is a veteran of the district court and a longtime senior judge with our court as well. This is case number 121012 in the matter of the marriage of Nancy and Joseph, is it Poggi?
Poggi.
Poggi, all right, thank you very much. This case is set for oral argument today. There is an appeal and a cross appeal. And I would ask that counsel for the appellant, Joseph, to enter appearances at this point.
Good morning. This is Jeff Carmichael with the Morris Lang Law Firm. I am here representing Joe Poggi. Also with me is co-counsel Lynn Ward of the Ward Potter firm.
All right, now, counsel, I want to ask you, do you want to reserve time for rebuttal?
Yes, I'll be doing the oral argument. I would like to reserve 3 minutes for rebuttal.
All right, now, counsel, we are involved with a cross appeal here. If you wish to speak to the cross appeal in your arguments, you may do so, or if you want to reserve some time in your rebuttal to reply to what is brought in the cross appeal, you may do that as well.
It's my intent to argue it during my primary argument, to do both the appeal and cross appeal.
All right, thank you. Then we'll turn to the counsel for the appellee, Nancy.
Good morning, Your Honors. Jeffrey Lowe appears on behalf of Nancy Poggi, now known as Nancy Blanchett, the appellee and cross appellant in this matter.
All right. And obviously, counsel, you heard what I said to opposing counsel. If you would just move in from whatever you're saying in reply to move into your argument concerning your cross appeal, just let me know when that occurs. And one additional point I want to give to all of you is that we're all getting used to this medium of oral argument by video conference. So what I usually do is, if I have a question, I'll raise my hand, and because there is a bit of a delay electronically when that occurs. So if you see my hand up, you might acknowledge me so I can ask my question and we can proceed. We have received your briefs and we have read those. We have also received a memorandum of the law concerning this from our research staff. We have read and understood that. So I can tell you, we may have some questions for you, so be prepared for that. All right, with that in mind then, Mr. You may proceed with your oral argument on behalf of the appellant, Joseph.
Thank you very much, Your Honor. As I indicated, my name is Jeff Carmichael, and I represent Joseph Poggi along with Lynn Ward. There's some key facts I think you need to keep in mind about this case, and that is that both of the petitioner respondent in this case are physicians. The petitioner is an emergency room doctor. The respondent is a plastic surgeon. The trial took place over 4 days. There were significant assets at issue, and I say significant, I mean millions of dollars were divided by the court between the parties. There was no debt associated with this marriage other than Joseph Poggi, my client, has a mortgage on his home that he bought, which is worth roughly a third of the home that he left and was granted to his ex-wife, Nancy. Her home worth approximately $1.2 million. My client's worth approximately $350,000. But there were other significant assets, including retirement accounts, investment accounts, business interests, all of that were significant and divided between the parties. The lifestyle of the petitioner continues in a $1.2 million home. The only twist in this case was that during the pendency of the case over a 24-month period, the petitioner was diagnosed and treated for breast cancer. Other than that, there are significant assets, a division by the court, and the issues that we have on appeal are two, and they're limited to the child support issues. One is whether there was adequate evidence to support the exceeding the guidelines going to the extrapolated income formula for child support. And secondly, whether the retroactive application of child support under the temporary order was justified by the facts and circumstances of this case. On the first issue, the question is whether the extrapolated income where you go to above the guidelines was justified in this case, given the fact that the parties are of equal assets, equal holdings. They both have probably more money than they're going to be able to use in their entire lifetimes based on the division that occurred at the time of the trial. In the journal entry, the court made findings with regard to exceeding the guidelines, exceeding the child support guidelines, and those findings are on page 6 of the ruling of Judge Dewey. They appear in our brief at paragraph 32. And what paragraph 32 indicates is that the court made findings that he said he applied the factors, including the standard of living, situation of the parties, relative wealth and income of the parties, ability of Joe Poggi to earn and ability of Nancy Poggi to earn, and the children, family history, tradition, past and present lifestyle, finds uncapped extrapolated support is appropriate and warranted. With regard to those findings, there is no factual basis provided, and that is what we are contesting, that there is inadequate factual basis to have done what the court did in this situation.
Counsel, may I ask you a question?
You certainly can.
Did you bring that issue of inadequate fact-finding to the court's attention?
We did, I believe, Your Honor, when we made oral argument and closing. We also, I believe, appropriately have now raised it on appeal. Under KSA 60-252A4, a party may later question the sufficiency of the evidence supporting the findings, whether or not the party requested the findings, objected to them, moved to amend them, or moved for judgment on partial findings. So, Judge, are we required to make that objection with regard to evidentiary findings? And the answer is no. The statute allows, and this is KSA 60-252A4, allows a party to object to the sufficiency of the evidence supporting the findings, whether or not you've objected to them prior to that. And I think, Judge, that is what we have done in this case with the appeal, specifically with regard to the issue of the factors giving rise to extrapolated use of the child support guidelines.
Is that the relief then you were asking for us to remand this for further fact-finding by the court? Is that what you're wanting?
I believe there should be clarification by the court. Yes, there is insufficient facts in our opinion to support what the court has done. If the court is required to go back and make those findings, I think it will become apparent that there is insufficient factual basis. And that's the relief that we're asking, which is consistent with the rule in the Bradley case, which says, the last portion of that rule, if the appellate court is precluded from extending meaningful appellate review, the case may be remanded, although no objection made at the trial court level. That is the relief that we're asking for. With regard to the second issue, which is the allowance of or the refund back to my client of the retroactive child support. What we're asking for there, Your Honor, is that the, excuse me, that's the second issue is the retroactive finding of retroactive deviation. The issue that we're raising there, Your Honor, is that the court abused their discretion in awarding retroactive child support under the temporary order without appropriate support from facts or factual finding.
Did the parties know that the court was going to go back and refigure the temporary child support after it entered its final decree?
The issue was raised, although the issue that we raised on the motion was the mistake made by the court, which was that the Judge Dewey put the retroactive award at the maximum level under the extrapolated formula, and was aware that our client had paid direct expenses during that same time frame. So it's like a double dip. What we suggested to the court was that was error to have that double dipping going on, or that amount of child support far in excess of what was needed, necessary, or allowable. And the court agreed and refunded our client back the direct expenses, but left the extrapolated level at the highest level it could go for child support. So I think in that regard, the court understood the issue, understood that when we filed the post-trial motion, seeking the relief, that it was appropriate, it was within his discretion, and he awarded that relief that we had asked for. I think that is entirely appropriate given the circumstances of this case and given what has occurred. I'd like to spend a few minutes before my time is up talking about the cross appeal in this case.
You've got about 3.5 minutes, counsel.
Thank you. On the cross appeal, there are two issues. One is the reimbursement of the direct expenses paid to Joe. And the other is the reduction of spousal support, the reduction of child and spousal support based on the 2018 income being significantly decreased. What we had done, Your Honors, we filed a motion under 259F seeking relief on the, as I indicated, the excess payment of child support based on the highest levels of extrapolated income and the direct expenses that were paid. That was appropriate. It was not beyond the scope of the issues in the case. It was directly before the court in terms of issues that the court was taking under consideration. And when the court made a mistake, we sought relief and the court agreed and granted that relief. So I don't think there's any reason for the appeal to be successful on behalf of petitioner on the issue of the repayment of the direct expenses that Joe paid during the temporary order. The second issue is that the evidence justified modification of spousal support and child support based on a material change in circumstances, which was a post-trial motion seeking relief based on Joe Poggi's 2018 income being significantly lower. The facts are without question, and that was that Joe Poggi's income in 2018 was $350,000. The 3-year average that had been used during trial to calculate support for Joe's income was $648,704. The decrease in 2018 is approximately 40% lower than the numbers used at the time of trial. For that reason, we believe it was appropriate for the court to consider reducing his child support and spousal support in 2018 based on a significant decrease in income. What the petitioner argues is, well, if you take a look at the percentages used in the worksheet, they're lower than that. And the judge did adjust the numbers, seeking and agreeing and deciding not to use the entirety of the 2018 decrease in income. But the decrease in income was real, and it existed, and it was material. And what the judge did then was to establish new child support and spousal support based on those adjusted income levels. He didn't adjust it quite as far as we wanted, but there was a material change in circumstances justifying the relief that was sought, which was decrease in child support, decrease in spousal support. I think that without question, the district court made the appropriate finding. With regard to the argument raised by petitioner, which was res judicata, I'm at a loss to understand that. There is no second cause of action at issue here. Res judicata has no application to the facts and circumstances of these motions, either post-trial or the motion to amend child support and spousal support. For that reason, then, I think that argument has absolutely no basis in law or fact to be applied to this case.
Thank you, counsel. Your time is ending, so if you'd like to sum up, please do so.
I believe, Your Honor, that the court made the appropriate determination on the motions that we had filed post-trial, which was the adjustment in 2018 income for lower child support, lower spousal support, and made the appropriate finding to reimburse our client for the direct expenses he paid during the pendency of the divorce. There was no evidence presented at the time of the divorce trial by petitioner of her lacking anything, lacking any income, lacking any ability to pay. We asked specifically, do you have any debts? Do you have any obligations? Do you have any loans that would indicate that the temporary support wasn't sufficient for your needs? And she said, no, I don't. And Judge, I think for that reason, the steps taken by the court were appropriate.
Thank you, counsel. All right. Mr. Lowe, I see your microphone's muted. There we go. You've got 15 minutes, counsel.
Thank you, Your Honors. Counsel, the distinguished panel, and may it please the court this morning. Thank you for your time and attention today. The district court properly applied the extended income formula when it calculated future and past temporary child support. And its decision was consistent with the requirements of the Kansas child support guidelines and accompanying Kansas law. For your note-taking purposes, Your Honors, you can look to the Kansas child support guidelines when it comes to extrapolated, or what many practitioners refer to as uncapped child support, by looking at section 3B3, and that's income beyond the child support schedule. In pertinent part, it recognizes in the Kansas child support guidelines that the court should exercise its discretion when considering what amount of child support should be set in addition to the highest amount on the child support schedule. But as denoted in the briefs of Nancy Poggi, the appellee, there are several cases that are very instructive to the issue of capped and uncapped child support. This court is very well familiar with these cases, as the majority of them arose from this court. Let me first highlight a few key points from the Patterson decision of this court from 1996. As we learned in Patterson, and I will acknowledge to the court that per Patterson section 3B3 of the guidelines does not create a rebuttal presumption requiring the absolute application of the extended income formula. Again, that's in the discretion of the court. But what the Patterson court did say, this court did say, that the court has, the trial court, wide discretion when setting the child support amount when the incomes of the parties exceeds the amounts on the child support schedules. And this court further held in Patterson that the trial court is required to consider both a capped and uncapped child support worksheet when assessing child support. That was done in this case, and that's not being challenged. We can move to the Leone case, and this case is probably most heavily relied upon by the appellant in his brief. However, Your Honor, it is still helpful to the resolution of this issue, and it's absolutely distinguishable from the instant matter because in Leone, the court was trying to explain the cap that was assessed in that matter instead of full uncapped or extrapolated child support. In Leone, this court found important to point out that the district court referenced in its ruling domestic relations affidavits, exhibits, testimony. The court file said it was supported the application of the income or extended income formula. The Leone court also provided additional information that summarized the parties had substantial assets, an argument that Mr. Carmichael was quick to point out to the court today. And it goes on to explain the imposed cap was, quote, for equalization of the ability to provide for the boys between their two homes, but does not convert child support into a disguised division of property, end quote. In Leone, the deviation was not to use the full income formula per se, but rather the deviation was capping the extended income formula at a monthly child support amount of $5,000. That cap is what the Leone court said required extensive explanation on behalf of the district court, and that was done in that case. Finally, the most analogous case, Your Honors, is the unpublished decision of in re Marriage of Wilson. That is 2011 Westlaw 471-7202 from this court in 2011. It's also referred to this court and family law practitioners as the Wilson 2 case because it was the second appeal, although the Wilson 2 case dealt with the issue of capped and uncapped child support and the first appeal did not. That case, I would ask the court to carefully review. That was an appeal by the father when he challenged, similar to this case, application of the extended income formula and argued that the court should only do so in cases where there's clearly a demonstrated need of the child that justifies the extended amount. In that case, similar to this one, the father specifically took issue with the court's findings, insisting that the explanation of the ruling about the potential effects of the drastic income difference of the parties is nothing more than a blind assumption that cannot serve as a substitute for appropriate analysis, nor in that case, the requisite fact finding with evidentiary support. Stated differently, that was a same argument that was presented to this court back in 2011, and this court rejected the father's arguments and upheld the district court's application of the child support determination. And this court said, quote, we disagree with the sufficiency arguments. The domestic affidavits were not the only evidence considered by the court. Both parties testified at trial and offered numerous other documents for the court to consider. We acknowledge some of those are not on the record for appeal. But Judge, as it applies to this case, please do not lose track of the actual discussion and findings of the trial court in the Poggi matter in the court's memorandum decision starting at page 6. Quote, the court has considered the evidence in this case as it applies to factors, including the standard of living and situation of the parties, the relative wealth and income of the parties, the ability of Joseph Poggi to earn, the ability of Nancy Poggi to earn, the needs of Joseph, Nancy, and the children, the family history and tradition, and the past and present lifestyle of the children. The court finds that uncapped, extrapolated child support is appropriate and warranted. Not only was there findings of fact, Your Honor, as we just stated for the record, but sufficiency arguments is nothing more than the appellant's way of complaining about the result. In the Bradley case, albeit distinguishable in the sense that it dealt with custody issues, not support issues, but that was a case where the appellant challenged the sufficiency of findings and the sufficiency of evidence supporting those findings, just like in this case. When the Kansas Supreme Court reviewed the Bradley decision, it held that the appellant's arguments about deficiencies in the oral and written findings of the trial court were basically complaints about the result, quote unquote, basically complaints about the result. Mostly, yes, Your Honor.
Is that what you're arguing here today, that that's what the what Joseph, the appellant, is arguing. He just doesn't like the result, so he attacks it by saying the trial court made insufficient findings. Is that the essence of your argument?
That would be the first part of the argument, Your Honor, precisely. The second part of the argument to make that transition is that Joseph Poggi did not properly bring this issue before the court. This court, the Kansas Supreme Court, has often held that it does not want people to come to the appellate level to then complain about sufficiency findings. We have a statute on point. It is briefed in the appellee's briefs about the ability to come to court and ask for additional findings of fact or to correct findings of fact. That was never done in this case. But before we get into that analysis, this court should know that neither the Kansas Child Support Guidelines nor any of the existing case law requires written judgment of a trial court to include an in-depth discussion of each factor considered when the trial court deviates from the presumptive child support amount. The appellant is trying to impose arguments on the trial court that simply doesn't exist. And so to answer your question, Your Honor, that's what I wanted to point out to the court. This court is also held, and we briefed this in our memorandums, that to have sufficient findings of fact, you really only need to cover those in Section E of a child support worksheet. If Section E is basically a check the box application, and that constitutes sufficient findings of fact, the court should note that the guidelines are not requiring an in-depth discussion over each and every one of the factors that the court applies. And
But counsel, let me interrupt you if I can.
Certainly.
This is not an ordinary case. When you're talking about incomes at this level, and this is an extraordinary case. The guidelines cover the vast majority of cases and those disputes. But really, we're talking something that's well beyond that here, correct?
Correct, Your Honor. And it is not the job of this court to go back and reassess all of the facts, arguments, and testimony that was presented to the trial court as to why it extrapolated child support. The job of this court is, did the court make sufficient findings of fact? And also getting into the second level of the argument of the appellee, that is, the appellant failed to object in a timely fashion to any of the inadequacies in Judge Dewey's findings at the district court level, as is required to do under 6252. We cited a plethora of cases, but the one that I want to point out to the court is the Hill versus Farm Bureau Mutual Insurance Company case from 1998. That is 263 Can 703. Quote, we also note that a litigant must object to inadequate findings of fact and conclusions of law in order to give the trial court an opportunity to correct them. In the absence of an objection, omissions and findings will not be considered on appeal. Where there have not been such objection, the trial court is presumed to have found all the facts necessary to support the judgment. So in response to your question, Judge Hill, that's what this court is tasked to do. There have been sufficient findings of fact. We've read those to this panel, and the appellant didn't do anything to say, give us more, tell us more, expand on those findings. The first time that you hear those, and you can look at the motion to alter or amend, is that it's brought up on appeal.
Counsel, could you move into your cross appeal in the very brief time that you have left?
Thank you, I will. On the cross appeal, Your Honor, what we're saying is that on a motion to alter or amend, the court giving credit to Joseph for direct expenses was beyond the scope of the district court's authority. And the main reason for that argument is that was never an argument, a claim that was presented at the trial court level at no point in time. In fact, as we point out in our brief, at the hearing on the motion to alter or amend, Joseph's counsel specifically stated, quote, please note, Your Honor, though that both in direct examination of Joseph Poggi and our closing arguments, at no time did we request you have Joseph Poggi being reimbursed for these expenses. So this is presented to you to show you some history, but it was not presented to you with a request that he be reimbursed.
Let me ask a few questions about
Sure.
that. The amount we're talking about here on the reimbursement of direct expenses, that's about $12,000, isn't it?
Correct. De minimis, admittedly.
Not a huge amount in
Correct.
considering everything else. I know that technically Joseph didn't argue for reimbursement of direct expenses at the trial, but isn't that only because he was asking the district court to order him to be responsible for direct expenses in the first place? Is that correct?
That is correct, Your Honor. That's what those exhibits and that evidence was intended to be presented to the trial court by Joseph, correct?
And then another factor would be that the reimbursement of direct expenses became a clearer issue when the court went back and ordered, refigured the $91,000 in temporary child support that he refigured. Isn't that correct also?
Yes and no. The retroactive child support that the court assessed was based upon incomes of the parties, not direct expenses. The only thing that the trial court heard was who was better suited to pay for the direct expenses of these children. Because in a shared residential arrangement, Your Honor, he or she who pays the direct expenses is typically the recipient of child support. That's why that was an important issue at trial. The reimbursement of direct expenses was never advanced by any party at the time of trial. It was advanced after the fact, which we're telling the court is improper on a motion to alter or amend.
Had Joseph expressly argued for reimbursement of direct expenses at trial, and the judge made that order, would you agree that under the circumstances that would have at least been an appropriate order?
Yes, Your Honor, I would.
Do you have any case law? I know you're saying that the court shouldn't have ordered this on the motion to alter or amend because it was never argued in trial court. But do you have any case law that addresses this issue in terms of jurisdiction? In other words, are you arguing that the district court simply didn't have jurisdiction to enter this order on the motion to alter or amend?
That's correct. And the authority for your note-taking purposes is the Ross-Williams case that we cited in our brief, 55 Can App 2nd, 524 from 2018.
Does that actually discuss the issue in terms of jurisdiction?
I believe it does, and I'll read the quotes. The purpose of a motion to alter or amend under KSA 6259F is the correction of a prior error by the district court. Here's the quote from Ross-Williams. Quote, "It is not an opportunity to present additional evidence that could have previously been submitted," end quote. And it goes on to say, a district court should deny a motion to alter or amend, quote, "if the movement could have, with reasonable diligence, presented the argument or evidence before entry of the final order," end quote. I believe that's jurisdictional.
I'm not hearing the word jurisdiction, though.
I would grant you that concession, Your Honor.
Okay.
I also think in the Weinrich case that we cited in our brief, it further goes on to state that a motion to alter or amend is not the proper forum, and I would say jurisdictionally, to bring up a new argument or new evidence that could have and should have been brought up at or before the time of trial. And that is also the case we cited. That's another Kansas Court of Appeals decision from 2006, 35 Can App 2nd, 582.
Counsel, your time has expired. You've gone on a little longer. If you wish to sum up, please do so.
I will, Your Honor. I would ask the court to review the issues on the briefs. But in conclusion, we have an abuse of discretion standard as it relates to the appellant's appeal, which means not one other reasonable judge in the same situation presented in a 4-day trial, taking the matter under advisement for weeks upon weeks, would have made the same decision that Judge Dewey did. That is a burden that the appellant has not and cannot overcome. As it relates to the cross appeal of the appellee, I would acknowledge Judge Malone's question that the amount in controversy is de minimis. The cross appeal probably wouldn't have been brought, but for the original appeal of the appellant. But still, it's a matter of how many times can we get another bite at the apple? If we don't like the result, let me try again and again and again. And the cases that we cited on our briefs speak to that point. So I do think it is jurisdictional. I do think that there is preclusion from the appellant bringing those arguments. By the way, the motion to alter amend was filed the exact same day that the trial court journal entry was filed with the trial court. Thank you for your time.
Counsel.
If there's other questions, please let me know.
Mr. Carmichael, you've got 3 minutes. Please, if you wish to reply concerning the cross appeal, you may do so. And you may begin.
Thank you very much. There are just a couple of issues that I want to point out and talk about. One is the issue of the retroactive recalculation of support under the temporary order, where my client was obligated to pay $91,000 in back support. We put evidence on at the time of trial that there was no shortcomings, no shortfalls, no debt, nothing left unneeded, unpaid for the petitioner, Nancy Poggi, under the temporary order. And what the judge did was simply look at the income and say, pay $91,000 without any indication of need at all by Nancy Poggi. And that is the definition of a windfall. It absolutely had no basis in terms of that payment being made based on any need, based on, and she had the evidence. Nancy Poggi didn't even try to put evidence on about what her expenses were for that retroactive, that look back. She would have had her financial records and could have easily demonstrated, this is what my expenses were. This is why we need a recalculation of support under the temporary order. There was no need ever established. And simply a payment of $91,000 without justification, without sufficient fact finding. That's why we believe that needed to be reversed. On the issue of the cross appeal, the argument that's being raised is, gee, you know, the petitioner, I mean, the respondent, Joe Poggi, didn't raise these issues in terms of the sufficiency of the evidence or the sufficiency of the evidence supporting findings. And that is covered by 6252A4, which said you don't have to raise those objections. That's appropriate for appeal. There's no question that what came out of Judge Dewey in terms of a ruling was a final order. And as a final order, my client has a right of appeal as a matter of right to the Kansas Court of Appeals. And that's what we've done. I don't see any basis based on the statute, which Mr. Lowe does not address at all, 6252A4, in terms of the right to proceed to object to the lack of evidentiary support for what the court has done at the lower level. And that's why we want the case remanded for further findings to see whether or not there is any factual basis for what the court has done in this situation. For that reason, I believe it's appropriate for the court to remand the case back, to deny the cross appeal as being unsupported. There is no basis based on the discretionary conduct and acts of Judge Dewey in his rulings on the refund of the $12,000, which clearly was in excess of what should have been awarded under the temporary order. And by the way, Judge Malone's question was good in terms of, you know, we were seeking to have our client be the party paying the temporary, pay the direct expenses. It would have been inconsistent for us to argue reimburse us the direct expenses when we were also arguing the direct expenses are a basis of which our client should be the one paying them as we go forward. Once the court ruled and became apparent there was double dipping going on, the motion that we filed was appropriate. The court agreed within his discretion, and gave us that $12,000 back. It is de minimis. For that reason, we ask that you reject the cross appeal.
Thank you, counsel, for all of you appearing here today and your fine arguments. We will take this under advisement and in due course issue our opinion. And be safe, all of you. Thank you for your attendance and your participation.
Thank you.
Thank you.